episode of Vienna Arbitration Talks. Today, I'm really excited to host on the line from the offices of the ICC in Paris, the new president of the ICC court, Claudia Salomon. Hi, Claudia. How are you?
Hello.
How are you? I've just mentioned that you've started your terms as the president of the ICC court, and congratulations on that, of course. How has it been?
Thank you so much. Thank you so much. It's been a whirlwind first week, but I'm just thrilled to have the opportunity to serve in this role.
Now, I can imagine. Did you get a nice office? That's
I did,
my first question.
Yes, I have a nice office and I have a view of the Eiffel Tower.
You have a view of the Eiffel Tower. That was the most important thing, I guess, with the Paris office, right?
Absolutely.
And I can imagine it's been overwhelming. You've been in Paris for a couple of weeks now, or how does that work?
Just since the start of July.
I see. Okay, so let me introduce you shortly to our viewers. Dear viewers, as I've mentioned, Claudia has just taken over as the president of the ICC International Court of Arbitration, and she's the first female president of the ICC court in its almost 100-year history. Outside of this role at the ICC, Claudia is an arbitrator in independent practice, specializing in investor-state arbitration and complex international commercial disputes. She's widely recognized as one of the leading arbitration practitioners of her generation, and before starting on her own, she was a global co-chair of the international arbitration practice at Latham at Watkins. Claudia has acted as arbitrator and counsel in countless arbitrations around the globe at all major institutions. And here's quite an interesting fact. A couple of months ago, we read about one of Claudia's arbitrator cases, which she's not really at liberty to discuss with us. But in any case, the US courts refused to vacate her award. And the reason I'm mentioning this case here now is because it was a dispute over royalty payments concerning the famous rapper Snoop Dogg. You have also this was a case that was related to one of your specialties. You know a lot about liquor law, right? if that's what it's called, right?
Well, this case involved the distribution of cognac, and Snoop Dogg had been one of the sponsors of the brand. And, you always wonder, how is it that you got selected for this case? And I was thinking back that, I had experience as counsel in a case involving gin. So I thought, well, maybe the arbitral institution thought that I had a specialty in spirits, and so I would be the right arbitrator for the case.
So basically now you have on your CV and your arbitrator appointment sheets that you are and you know how to apply spirits law, or how does that work?
Maybe so, along with, energy, mining, investment treaty, and other, key sectors.
Exactly. Claudia, about our topic for today, you may have seen our interview with Santtu Turunen, the former Secretary General of the Finland Arbitration Institute, where we spoke about value proposition and the whys of international arbitration. So I wanted to talk to you today about the adoption of the client mindset in international arbitration. You have been quite passionate about this. You've spoken about it at the 6th Atlas lecture. And first, if we start, we often hear that we need to focus more on client service and client expectation. We've been saying that we need to make arbitration more efficient, more faster and better. But what do these things actually mean? Especially, what does better actually mean?
No, it's a great question. And what we know is the legal services industry has gone through a major transformation over the last 25 years, focused on client service, although of course I think the clients would say that we still have a long way to go in that regard. But the transformation has really been in responsiveness, in clarity of communication, in articulating and assuring that outside counsel are providing true value to their clients. And that transformation has also taken place at the same time that we've really seen a major transformation in the role of general counsel, and as a result of the highly regulated environment. So no longer can we have a situation in which the business teams are doing deals and just bringing them to the lawyers to document them. Instead, the general counsel, the in-house counsel, are working hand in glove with the business teams as true assessors of risk and as true advisors to the C-suite. And so my proposition is that it is time for international arbitration to go through this same transformation focused on client service. Of course, outside counsel have clients, the parties in an arbitration, but the arbitral institutions and the arbitrators can also be thinking about the parties as the clients. And I don't mean it from a legal standpoint or from a tax standpoint. I mean it, from a mindset perspective, that we are thinking about the arbitration process in a way that engages the parties more into the process. And that way, I believe we can have a better match between the parties' expectations of the process and the dispute resolution process itself.
You've mentioned party expectations, and I think it's refreshing. We keep hearing more and more about party expectations, but still, I would imagine we should be spending more time discussing this at our conferences, maybe in addition to all the procedural things that we discuss at our arbitration conferences. But in any case, how do we get these general counsel to attend? I mean, there are some that you meet every now and then at these conferences, but I would imagine it would be very good for this client-based approach to bring these people to discuss these things with them when we talk about our procedural things as well, of course.
Yeah, I think the nature of conferences result in kind of the arbitrators, the academics, the outside counsel talking about very important procedural and legal questions about arbitration that are fundamental to the process. But, general counsel and in-house counsel are incredibly busy. So if you have a multi-day conference that has high fees, they're not in a position to be able to just listen in that context. They need to be in a forum or in a context in which there can be a roundtable in which they are sharing information with each other, and that the framework for engaging with them meets their schedules. So 1 hour increments, I think, is the best way to be able to engage with in-house counsel. And that's really what I've done in the transition leading up to the start of my role. And even already in this first, week and a half, having direct conversations with in-house counsel to find out what are their perceptions, what are their perspectives, and how can we engage them more in the process.
When you've talked to them, you must be able to identify this better than me. What do the clients want? I guess it's not as easy just to say clients want arbitration to be faster and cheaper, right?
Absolutely. When a party is in an arbitration, they don't want an arbitration. They want to resolve a dispute. It's the way Richard Susskind talks about how when someone goes to a neurosurgeon, no one wants neurosurgery. They want health. And neurosurgery happens to be the method by which, one can achieve health when one has a particular problem. And that's the situation with arbitration too. At the end of the day, the parties want a resolution of their dispute and they want to get back to business. And so from my perspective, the ICC court, ICC arbitration is focused on helping business get back to business. So we say, what do they want? I think we have to, as I've said, engage them more. This could be as simple as having the in-house counsel or the business representatives copied on all communication from the arbitral institutions and the arbitrators. then they're receiving the information in real time. Another technique that is, something we've talked about for so long is inviting in-house counsel to participate in the case management conference or that first preliminary hearing. What I did as the chair of a tribunal recently is do more than just invite them. I let it be known that they are welcome, encouraged to attend. Of course, their attendance was not mandatory. What that meant, we did this preliminary hearing virtually, and there was a minor dispute about when the hearing should take place, the evidentiary hearing. And instead of having counsel kind of take their firm positions and then having all kinds of follow-up that we might have to have after the preliminary hearing, we were able to take a pause, put everybody on mute, have outside counsel talk to their in-house counsel, their clients. They were able to come back, and there was actually a very easy way to resolve the dispute over the dates. That's something so minor, but it's actually just goes to the heart of efficiency.
It can take a lot of time, right? I mean, otherwise.
Exactly.
Yeah. Mm-hmm.
And just, one last point, by having in-house counsel there, the procedural timetable is reflecting their interest. If they have a desire to have a hearing or an award before year end, or if they actually want to have the opportunity for a pause before the hearing, so maybe there's time for negotiation before everyone dives into the cost of a hearing, the in-house counsel's perspectives can be heard right then and there.
I was wondering, how do we include these in-house counsel better? You've mentioned that they should be copied on the communications, the participation in the case management conference. I think you've put a couple of proposals, right? I think at the Atlas lecture already.
Yeah, so those are obviously two, and then kind of thinking about whether in-house counsel, what they want in terms of timing. I had just mentioned that maybe there's an interest in having a pause. When I served as counsel for many years, I always heard everybody talk about what clients want or what parties want is for the arbitration to be faster and cheaper. And we know that is the case for some disputes, particularly disputes involving SMEs, small and medium-sized enterprises, or for lower value disputes. But in some instances, my clients were focused on trying to have the case go and deal with every aspect of it. They were not necessarily, they recognized that the complexity of the case required time to deal with it. And so that was, this wasn't an issue about timing. It was an issue about, is the process going to meet their needs in terms of having the ability to get the information they want or make the case they actually want or assure that the arbitrators understand the issues. And so if we're judging arbitrators and institutions based on speed and cost, there's a hesitancy to potentially have pauses in the schedule. And there's also a real push to have the procedural timetable set at the very beginning of the case. But it might be that after the first round of submissions or at some other point in the case, when the issues in dispute are better clarified, there is an opportunity to adjust the procedural timetable. And so I'm not saying this is the right approach in every single case, and the fundamental piece is that there is no one-size-fits-all approach in every case, but I think we have to be thinking that we don't want to be locked into the procedural timetable determined at the first case management conference or the first preliminary hearing, and that's sacred and cannot be adjusted when it might make sense once issues get clarified. There are perhaps less issues in dispute once further exchange of information takes place or other arguments get raised, and that we consult and consider the parties' interests in the timetable as the case progresses.
Could it make sense, for example, that we organize first a procedure or timetable up to a certain point in the proceedings, and then for I don't know, maybe even organize a midstream conference or a bit of a, not a proper hearing, but a mini hearing on some issues where you already discussed substance, and then have another round of submissions? I mean, I guess that was what arbitration should be about: flexibility, right? And
Yes, what you just described is a great approach for certain cases. And what happens is, because of everybody's busy schedules, there's a desire to have this hearing date set. So concerned that if the case progresses and then you want a hearing in the next few months, that the arbitrators or the parties are not going to be available. And so that's something that counsel and the parties really have to be thinking about when they're selecting the arbitrators in terms of availability. And of course, when you ask an arbitrator at the start of a case, do you have enough time over the next 18 months? Everyone says yes, or you don't really know what your time is going to be. But I think we have to be thinking about this availability and the potential for when evidentiary hearings might take place, with some real focus at the beginning of a case to make sure that scheduling is not becoming the reason why something is delayed.
I was wondering, from the perspective of an institution, from the perspective of the ICC, how would you identify what the parties want in each particular case? Because as we know at the ICC, the case managers are quite involved in the cases already. So I imagine there is some communication there, right?
Yes, certainly. I mean, the Secretariat is open for communication with counsel when they have questions. They're open for communication when issues arise, not to upend the arbitration process, but to know that they can be a place where counsel can raise issues if there is such issues. And ultimately, we have to assess whether we need to get more feedback from the parties at the start of a case, even before the tribunal is constituted. And that's something we'll certainly be looking at.
One of your proposals was, I think, still that we can employ technology better, right? What did you mean by that?
Well, I think even the fact that we're utilizing the technology of the day right now to do this interview, in the context of the pandemic, we've all become much more comfortable with the technology that is available. But in so many respects, we're utilizing technology to do things that we would otherwise be doing in person. We're just doing it. We're doing what we otherwise would be doing in a different way. And what's exciting and interesting about some of the new technologies is how it can actually change the way we work and the way in which we approach problems and how we communicate and manage issues. And some of it we don't even know what is to come, but to be positioned in a way that we can be open and utilize that in multiple ways. Of course, it's the communication tool, it's the management of information, it's the disputes that will arise as a result of technology, and it's of course what we see in terms of AI and potential role that AI will have in decision making in the future.
Well, we can expect for the ICC to keep an eye out on that, I guess, right?
Absolutely.
Another one was transparency and predictability. ICC has been publishing some decisions. I think there was also that the ICC is now also reasoning its decision on challenges. The court, I mean, I think. So, what are the developments there?
Certainly, the publication of awards in an anonymized way, unless the parties object, but also the providing of reasons to the parties for decisions regarding challenges of arbitrators. And so if any one of the parties wants decisions provided, those will be. Those, of course, just would go to the parties, but what will result is a compendium of decisions, and, again, in an anonymized fashion, that's going to provide so much information to the global business community, the global arbitration community, about the ICC's approach to challenges. And to me, that is a core component of transparency. It's a core component of assuring that everybody has equal access to information. I think it will lead to less challenges and less appointments of arbitrators who would likely be challenged, because we will then be in a situation where everybody has information about the type of person who would be subject to challenge. And so I think that will then lead to a better process. Ultimately, sometimes I hear, oh, well, the arbitration rules are getting amended so frequently, or they're getting so lengthy. And to me, more detailed rules is an essential aspect of transparency, because then the parties are no longer wondering whether arbitrators or the institutions are going to do something based on their inherent powers. It's clear that they have the power to do it or they don't. And so that also is something that I think reflects the value of the global business community, which is a desire to understand and have access to information.
And I assume also a little bit more efficiency if the parties then don't spend a couple of pages in each submission writing whether the tribunal actually has the power or not. I think the ICC rules, there was a recent amendment on the exclusion of party representatives, for example. I would imagine that will save some submissions whether this is actually possible under the ICC rules or not.
Exactly. From my perspective, that rule should result in arbitrators never having to exercise their power.
Exactly.
Because it's letting everybody know that if counsel's going to try to play that game, it will be put, an end will be put to that process. And so we would expect counsel just not to try to do it.
That's true. I think the last proposal you had was diversity. Can you tell us more about that?
Sure. There was just an announcement that the ICC Commission on Arbitration and ADR has created a task force on my recommendation focused on disability, inclusion, and international arbitration. For me, diversity broadly defined is an essential aspect of the legitimacy of international arbitration, because we have to reflect the diversity of the global business community. And the reason I wanted to be focused on disability inclusion as my first act as president of the ICC court is that we are emerging, hopefully around the globe, out of this pandemic. And we have the opportunity to decide what world are we going to, how are we going to operate in this new world? Because we're not going back to the way it was. We've experienced a situation where in many respects, all of us are in some ways disabled. I use that term to say that, of course, we are not in a position to travel. We are not in a position to function the way we were used to. And so we realized that we could adapt and we could also accommodate other people's circumstances. So, in a situation where we may have thought, well, if you can't work 8 hours a day, you must be inefficient. Now, if you can't be in front of Zoom for 8 hours, there might be a recognition that, well, a lot of other people can't either. And so we can accommodate. We also understand that there is an absolute need for people who are creative and innovative for our problem solving. And people who are living with disabilities have to be creative and innovative in their lives every day. So, from my perspective, if we do something as simple as adding an item on our agenda for the case management conference, just like we now ask, are there any GDPR issues? Are there any cybersecurity issues? Questions we never asked a few years ago. If we ask the basic question, are there any disability inclusion issues we need to take into account as we think about the procedure and the procedural timetable, we have changed the conversation around disability. And for me, there must be many other things we can do. And by creating a task force of people who are living with disabilities or who are allies in this regard, I know we're going to be able to come up with an important list of guidelines that will be beneficial for the entire arbitration community.
Then the tribunals can look at these things and see what they should be they should take into consideration. I think it's a wonderful idea and a very welcome approach. Well, thank you, Claudia. Thank you very much. It's really been a pleasure to talk to you about this quite important subject. In any case, I will for sure try and adopt more of a client mindset also in my own cases. So, and I appeal to our viewers to do the same. Thank you so much. Best wishes for the presidency, of course.
Thank you so much. It's an absolute pleasure and honor to be on this program, and I just really appreciate the opportunity.
Thanks for taking the time. Thanks. Greetings to Paris.
Thank you.
Thanks. And to you, the viewers, thanks for watching another episode of Vienna Arbitration Talks. Don't miss the next one, but in the meantime, greetings from Vienna and stay safe.